matter of Haddad and Rostamani and others.
My Lord, I
Yes.
appeal on behalf of Dr. Haddad. The learned friend, Mr. Moriarty, Queen's Counsel, and Mr. Robertson appear on behalf of the defendants 1 to 7, and the learned friend, Mr. Fenwick, Queen's Counsel, on behalf of the 8th defendant.
Yes.
The issues to be ventilated today are fairly narrow in their scope. The first, I think, that needs to be dealt with today relates to the skeleton argument before we can go on to discuss issues of costs.
Yes.
The skeleton argument is ultimately, and this is in reference to your Lordship's comments in refusing permission to appeal and subsequent emails, is ultimately my responsibility. It was filed under my name and ultimately with my approval. I was instructed by Dr. Haddad on a direct access basis. Throughout the proceedings, I took my instructions ultimately from him and understood he had the assistance of lawyers from Dubai who had an intimate knowledge and understanding of the extensive litigation in Dubai. I wasn't instructed on all aspects of his case, and I wasn't instructed either to prepare all documentation in his case for the appeal. He had, as I understood it, the expertise of international lawyers. I was not instructed to draft the skeleton argument or grounds, but really to give an overview. That was my responsibility in the direct access scheme. The document in that sense then is a composite document, and ultimately, and perhaps to my folly, I relied too heavily on the knowledge and researches of my late client and his legal team.
Did you read it before it was sent out?
I did read it, my lord.
So you saw that it was making allegations of dishonesty against others involved in the case?
I did see that.
And you would have known also that it was in breach of Lord Justice Newey's order as to page limit?
Yes, I would have been aware of that also.
Right.
I can't waive privilege, but I can say that I was assured that in terms of the arguments raised and relied upon, there was sound evidence and arguments. And Dr. Haddad wishes, I think as your Lordship may know in recent correspondence, he wishes to use this material in a potential new action. I don't know what that is going to be. I'm not instructed in that.
Well, one thing that went through my mind when I directed this hearing should take place would give whoever was responsible for the skeleton argument an opportunity to apologise publicly to those who had been accused of dishonesty.
Yes, and I do so, because ultimately I have to fall on my sword. It's my sin, it's my mea culpa, so to speak, and I do apologise, and for that I am truly sorry. The court takes the view that those allegations should not have been made. They should not have been made, and I ultimately will take the responsibility for that. And so I'm sorry to each of my learned friends, their expert, and their instructing solicitors for those allegations that were made.
Yes, all right, well, thank you for that. Is there anything further you want to say?
Simply this, that I certainly don't wish. I know that Dr. Haddad has produced further material in relation to those allegations and still stands by them. I'm not instructed to pursue those allegations today. I think he is going to be dealing with that aspect of any further action himself personally. But as I say, I'm not going to pursue any of those allegations today or seek to justify them.
Yes.
Can I just add this as well? I took my eye off the ball. I did so because I don't want to go into too much detail, but in 2020, on the 6th of December, I was admitted to hospital. Those health difficulties persisted throughout 2021 and into 2022. As I say, I don't wish to publicly go into detail in relation to those, but can do so if your Lordship requires me and provide evidence for those. So, as I say, I've had a a 17, 18-year-long unblemished career. And as I say, I took my eye off the ball. I shouldn't have done so, and I apologise to my learned friends.
Yes. All right. Thank you very much, Mr. Moriarty.
My Lord, in the light of Mr. Backey having apologised for making those allegations of dishonesty generally, and not seeking to support allegations of dishonesty, which plainly were unfounded, I've got nothing further to say unless your Lordship wants me to answer anything specifically.
No. All right. Well, you want, what are you asking for? You're asking
Costs.
for costs.
Yes. Would you want me to develop that now?
No, I don't think I need to trouble you about that.
We're asking for costs on a indemnity basis, and you'll have seen the statement of costs, my Lord. And
I'm not sure I've seen the statement of costs.
I think it may have been put in your bundle now.
Has it? Whereabouts?
It should be, is it tab 18? Tab. Tab 18. I mean, your Lordship will have seen from the amount of paper that's been involved in this case that getting to grips with the allegations with a view to then writing a short 3-page statement has been a very, very, very taxing task. And if it wasn't for the fact I was wearing a wig, my Lord, you'd probably see where I've been tearing my hair out for the 2 or 3 days I spent having to read through the documents and read through the schedules. In those circumstances, in my respectful submission, although we're talking about £80,000, they were properly incurred, and we ask you to assess costs on an indemnity basis in that amount.
Yes. And this covers...
This only covers the appeal. It doesn't concern any costs before Mr. Justice Zaccaroli on the application
Right.
to appeal.
But it covers the hearing today as well, does it?
It does, yes.
Yes, I
It's a
see.
very small amount. I think it's 1,600 for me and 600 for Mr. Yeah, 1,600 for me, my Lord, and 600 for Mr. Robertson.
Yes. All right. Thank you very much. All right.
Can I just draw one correction to your attention, my Lord? I know it's a very small point, but in paragraph 6A of the skeleton, there's an error in as much as we referred to there being 158 grounds of appeal. In fact, that's wrong. That was the grounds of appeal before Mr. Justice Zaccaroli. They've been reduced to 66
Yes.
by the time, but it's still, obviously, they weren't concise.
No. No. All right. Thank you very much. Mr. Fanning, do you want to add anything?
My Lord, I adopt the same position as Mr. Moriarty. We were guilty by association for adopting the argument of Mr. Moriarty and Ms. Jordan's witness statement. In view of what Mr. Backey said, I don't wish to say anything further about that. We also asked for our costs. The cost schedule, which is relevant to this, should be at tab 16 of our bundle, and it comes to a total of just over £49,000. 2 3-page statements, the distillation of a great deal of material, and careful attention to questions of dishonesty, and the importance of being here today in order to see what was said about the allegations of dishonesty, which we see from Dr. Haddad's witness statement, which he'd asked to be put before the court today in course with application for reconsideration. He seeks to maintain them. So it was important we were here, and I asked for our costs on the indemnity basis.
Yes. Do you want to say anything about either the principle or the figures?
Not the principle, but certainly in relation to the figures. I can see force in my learned friend's argument that they would need to pay some attention to the appeal with respect to allegations made against them. But in relation to the other aspects of the appeal where allegations have not been made personally against them, in my respectful submission, they should not be entitled to those costs. Had the allegations of dishonesty not been made, they would not have been required to attend today. They would not have been required in reality to attend to the other grounds of appeal which have failed. So, for example, in relation to the grounds of appeal relating to the service out, for example, they wouldn't have been asked to comment on those, and there should be no reason why work reading that or looking at that should have incurred costs, and it appears that that has incurred costs. So in my respectful submission, a proportion of these costs may be justifiable in principle, but certainly not all of them. And in my respectful submission, perhaps 30% of what is asked for would, in my respectful submission, be generous to my learned friends. Great.
Yes, thank you very much. On the 15th of June 2022, I dealt with an application for permission to appeal in this case. I was faced with 58 proposed grounds of appeal, which were supported by a skeleton argument signed by counsel, Mr. Neil Backey. The skeleton was 25 pages long, but it was accompanied by very many pages of appendices, so that the material relied on essentially as a skeleton argument was well in excess of 25 pages. This was in breach of an order previously made by Lord Justice Newey when a very extensive skeleton argument had been filed in support of the application for permission to appeal, and he directed that it should be reduced to 25 pages. I refused permission. Essentially on the ground that the judge's conclusion that a failure to give full and frank disclosure in the court below when dealing with the question of service was deliberate, and that this was in itself a sufficient ground for the order which he made, quite apart from any other consideration in any of the numerous grounds of appeal. I added, quote, 8, however, it would be wrong to leave the matter there. 9, first, the applicant's skeleton argument is incoherent in places and falls far short of what is required to assist the court on an application of this nature. It is surprising to see a document of such poor quality settled by counsel. That is itself concerning. Second, it includes allegations of dishonesty on the part of the respondent's expert witness, solicitor and leading counsel, together with an allegation of bias dressed up as, quote, apparent, unquote, bias on the part of the judge. At first sight, it is hard to see that there is any proper basis for these serious allegations. 11, I emphasise that the purpose of the hearing which I have ordered is as set out above, that is to say, to consider whether there is any proper basis for the allegations of dishonesty referred to below, which are made in the applicant's skeleton argument, and if not, what the consequences should be. It is not to enable the question of permission to appeal to be re-argued. That question has been decided by this order. That hearing has taken place today. Mr. Backey, for the applicant, has accepted that the skeleton argument is his responsibility. It was filed under his name and with his approval. He has explained that he has been instructed on a direct access basis by Dr. L. Haddad. I have to say I find that difficult to understand, since there are solicitors, Giambroni and co, on the record. I don't see how there can be solicitors on the record combined with direct access counsel, but I need not explore that further. Mr. Backey has said that he was not instructed to draft the skeleton or the grounds of appeal, and did not do so, but gave an overview. He has confirmed, however, that he was aware of the allegations of dishonesty contained in the skeleton argument, and aware also that the skeleton argument exceeded the page limit directed by Lord Justice Neary. He has, I'm glad to say, apologised publicly for the allegations of dishonesty contained in the skeleton argument, although he has also made clear that Dr. Haddad stands by those allegations and may be seeking to take them further in due course. However, quite rightly, Mr. Backey has not sought to justify them. I wish to make clear that on the basis of the evidence before the court, those allegations have no substance whatever and should never have been made. I cannot see how they could properly have been made in a document prepared by or filed under the authority of either counsel or solicitors. So far as the solicitors instructing Mr. Backey are concerned, it appears from what has been said by Mr. Kizar Arif of Giambroni and Partners that he simply received the skeleton argument from Dr. Haddad directly, assumed that it had been drafted by Mr. Backey, and therefore filed it in support of the application for permission to appeal. I find it very difficult to see how that is acceptable conduct either, since it must have been apparent that it was in breach of the order previously made by Lord Justice Neary. Mr. Backey has accepted, however, that he took his eye off the ball in approving the skeleton argument in the way that he did, and has referred to personal difficulties which may have affected him at the time. In these circumstances, the respondents seek an order for costs, both of responding to the application for permission to appeal and of today's hearing. The position is aptly summarised in the skeleton argument served by Mr. Justin Finnick, Queen's Counsel, on behalf of the 8th defendant. Quote, in short, the appellant has failed to comply with either PD 52C or the orders of Lord Justice Neary, with the result that R8 has been required to consider and respond twice to skeleton arguments which are prolix, unfocused, incoherent in parts, contain serious and improper allegations of misconduct against R1 to R8, and which are supported by bundles of evidence and authorities which run to thousands of pages. Close quote. What is said there in relation to the 8th respondent applies equally to the 1st to 7th respondent, represented by Mr. Stephen Moriarty, Queen's Counsel. Although the normal practice of the court is that a respondent is not entitled to its costs of the statement filed pursuant to PD 52C, resisting the application for permission to appeal, in this case, the conduct of the appellant has been, quote, out of the norm, close quote. It is indeed, I hope, about as far out of the norm as it is possible to be. In those circumstances, the respondents seek their costs of responding to the permission application and attending this hearing and seek them also on the indemnity basis. In my judgment, that those applications are fully justified, and I order that those costs should be payable to the respondents by the applicant on the indemnity basis. I have before me schedules of costs which cover both the resistance to the application for permission to appeal and the hearing today. In the case of the 1st to 7th defendants, the costs are in the sum, the costs claimed are in the sum of just over £80,000. In the case of the 8th defendant, the figure is £49,000. Mr. Backey submits that those figures should be reduced, but in my judgment they are justified, applying the indemnity basis. An enormous amount of work must have been required in order to distill the material into submissions of the length required for a statement resisting permission to appeal, and even though that has a page limit of only 3 pages, a vast amount of material had to be considered in order to produce those documents. Accordingly, I assess the costs summarily in the sum of £80,000 for the 1st to 7th defendants and £49,000 in the case of the 8th defendant or respondent. I should add, and will make it clear if I am asked to approve a transcript of this judgment, that the allegations of dishonesty related directly to the 1st to 7th defendants rather than the 8th defendant, although the 8th defendant's case was inevitably going to be tainted if there had been any substance in those allegations, which, as I've said, there was not. Anything else?
Lord, sorry, this will come as no surprise to me.
I was simply going to ask Your Lordship to adjourn formally my application for restraint orders to be restored if so advised.
Yes. Very well, I will do that. I will also, I'm not sure I've done it yet, have I? Did I certify that the permission to appeal application was totally without merit?
Not yet.
No. All right, well, I will
You do so. I'm very grateful.
Yes. Did you want to say something, Mr. Backey?
Yes, I'm instructed, and I was saying to my learned friends, this will come as no surprise to them, but to apply for permission to appeal the costs ruling that your lordship has just given.
Well, I'll refuse that.
I'm grateful.
Sorry, let me ask, which aspect of the costs refusal are you asking to appeal? The order that your client pay costs, that it be on the indemnity basis, or the quantification?
All of it.
Well, you didn't resist the first two.
I didn't, but it will have to be on the basis of the indemnity basis and the amount.
Right. Well, I will certify as totally without merit an application for permission to appeal in relation to payment of costs and the indemnity basis in circumstances where that was not even opposed in submissions by you. It seems to me to be absolutely misconceived to ask for permission to appeal in those circumstances.
I'm grateful.
Thank you all very much.